First of all, thank you everybody very much for attending. This discussion is part of Greater Tampa Realtors monthly ongoing series with the Government Affairs Committee, where we bring in guest speakers that are local to our community, that are specifically in the real estate industry, to talk to us as realtor members, as business owners, as homeowners, about what's happening in the real estate profession. Today, we're especially excited to have Juana Watkins come speak with us today, specifically talking to us as realtors, as property managers, as tenant reps, as we navigate compliance with Hillsborough County's new Tenant Bill of Rights. But with that, we'll go ahead and dive right in. I'd first like to introduce our speaker today, Juana Watkins. She is a native of Pensacola, Florida. She graduated from Florida A&M, and as well as FSU College of Law. She began her career as an attorney with the Orange County Public Defender's Office, and that turned into a love of real estate when she joined DBPR as senior attorney. Then over the next 16 years, she went on to serve as chief attorney and deputy director of the Division of Real Estate before she was appointed by Rick Scott to serve as the director of DBPR for nearly 7 years. She's worked with Florida Realtors first as a senior counsel from 2005 to 2008, and then returned as interim director in executive offices of the Associated for the General Counsel's Office. Today, she serves as the Vice President of Law and Policy, as well as General Counsel for Florida Realtors. So with that, Juana, I turn the floor over to you. And again, thank you very much for coming today. We really appreciate it.
Thank you all for having me as I Zoom from meeting to meeting, giving poor Jacob and Nico a heart attack, I'm sure. I'm without my assistant today, so I'm like searching for the link, like where is the link? But it is always a pleasure to be able to come to you all and speak to you. You all are busier now than ever before as practitioners. And so while I am thrilled that you all are out there and you're so busy, and real estate is more on fire than ever before, I have the privilege and honor of telling you all the bad stuff that's happening out there that could trip you up. So let's talk about one of those things. It's not necessarily a bad thing, right? But if I'm honest, when members call us on the hotline and they talk about source of income, they're not all that happy about it, if we're honest, right? They're not thrilled about source of income. So I want to talk to you about it because I don't want any of you all to kind of fall prey to some of the testers and the lawsuits that we've seen historically out of South Florida as it relates to source of income. Okay, so let's talk about that. Let me share my screen, get you the PowerPoint. Okay, so source of income. This is not Florida Realtors' first rodeo with this whole source of income issue. We have been dealing with it for a very long time, but obviously in Hillsborough County, this is fairly new for you all. Back in March, the Hillsborough County Board of County Commissioners voted to pass this Tenant Bill of Rights, source of income anti-discrimination bill, and notice of late fee ordinance that they kind of collectively refer to as the Tenant Bill of Rights ordinance. So kind of three components here: Tenant Bill of Rights, source of income discrimination, and notice of late fees. Those are the three basic components that we're here to talk about today. This notice or this Bill of Rights, it became effective March 15th, but like most laws, right? It becomes effective and then there's this lead up time to give people time to learn about it and become aware of it and figure out how to comply. So July 1st was the compliance date or the enforcement date, so to speak, of this new law. Now, we're going to talk about the notice requirements and the late fees and all that, but at the heart of all of this is source of income protection. I mentioned this isn't our first rodeo. Florida has seen source of income for a very long time. To our south, your fellow realtors in Broward and Miami-Dade County they've dealt with source of income for a long time, for years now. Now you have joined them. You should also know that the city of Gainesville has joined the group, the list, source of income protection. So it is increasingly becoming more popular as governments, as cities struggle with affordable housing, because rental prices are exceeding the cost or the income of many citizens, not just here in Florida, but across the nation. So there are many states that have added on a state level source of income as a protected class in their state. Florida is taking the approach of allowing local governments to address this type of protection. So far, Broward, Miami-Dade, Hillsborough, City of Gainesville, and Daytona, Volusia, they are discussing the issue. So what is it? In Hillsborough, this ordinance provides that landlords cannot refuse to rent to a tenant because of the tenant's lawful source of income. And that lawful source of income is defined as a profession, an occupation, a job, any government or private assistance or grants or loans for housing, like the voucher program or Section 8 that we're also familiar with hearing about. Veterans Affairs support housing vouchers or Social Security income. Sometimes it's a gift or an inheritance. Maybe the person doesn't work because they have an inheritance that does not require that they work. It's modest, but it's enough for them to live off. Maybe it's a retirement benefit that they have, or a trust set up for their benefit. It can come in the form of alimony or child support or some other form that is not a traditional, W-2 or, business income. So just keep that in mind, that it's not just about Section 8, and that's where most minds gravitate to. And before I get into the other aspects of Section 8, I want to talk to you a little bit about the experience in South Florida, and talk to you a little bit about the experience of your fellow realtors there. When this started, and it continues to some extent now, there are, as we know, we call them legal trolls, but there are plaintiffs' attorneys who make a living looking for advertisements of realtors in South Florida that have the phrase, "No Section 8 allowed." Okay, so please be mindful of that. So as we talk about this presentation today, don't just focus on the denial of housing. Source of income discrimination can take many, many forms. You have to start planning your business from the advertisement of the property, your forms, your documents. All of this needs to be examined to ensure that you are following the ordinance that we're talking about, and you are protecting yourself against any lawsuits that will come, that I hate to say will likely inevitably come as a result of this adoption of source of income protection. So think about that as we talk about these prohibited aspects of source of income protection. It is unlawful for any person to refuse to rent or lease. We got that. We understand that that's what this is about. But listen to these other aspects. Refuse to negotiate or otherwise make available a rental unit. Okay, that we understand that one. That one's pretty clear to us. But it's also unlawful to discriminate against a tenant in the terms, conditions, or privileges of the rental or the lease for the rental unit. Okay, to use a financial or income standard in assessing eligibility. But what about the 3 times the rent, Juana? We're going to get to that. We're going to talk about that in just a bit, because sometimes you're just trying to properly screen, but you can run afoul of source of income protections by using income assessing standards or eligibility criteria that discriminate against someone based on their income protection. It's also prohibited to represent to a tenant that because of the tenant's lawful source of income, that a rental unit is not available. I just don't even want to deal with it, Juana. So I'm just going to say that the place has been rented. That runs afoul of source of income. To make, print, or publish any statement or advertising discriminating against source of income. I once saw a list where the plaintiff's attorney went through realtor.com or something like that, put in the keyword Section 8, found, 10 rentals that said, no Section 8. And that was 10 lawsuits, right? The demand letters came out almost immediately. Okay. So be careful with your advertising. Check your website, check your forms, make sure that you're not discriminating. And it is also prohibited to induce or attempt to induce another person for profit to rent a rental unit regarding entry or prospective entry into a neighborhood with particular lawful sources of income. So those are just kind of the legal, highlights of what is prohibited. Now, why do these governments keep adopting source of income protections? Well, it's not a listed category under the Federal Fair Housing Act. It's not. But as municipalities struggle with fair housing, and as they struggle with homelessness, they are starting to come up with these incentive programs, voucher programs, subsidized housing programs. And they want landlords to accept these programs. And so the federal government has said, listen, and so with the opportunity zones and things like that, and Section 8, and many of the local governments have also said, listen, we know from studying this issue that oftentimes source of income is used as a proxy for race discrimination. They say that source of income, while a lot of people think, oh, Section 8, that's what we mean by source of income. There are many veteran housing programs where veterans are being hurt because landlords don't want to take veteran voucher programs. So there's a no voucher process that covers both Section 8 and veteran preference or veteran vouchers. Source of income disproportionately impacts children negatively. And while then it's not intended to be familial status discrimination, we start to get into familial status territory because many of the families in need of the voucher assistance have children. And we know that familial status is a federal protected class. So now we start to look at the disparate impact of source of income discrimination. I didn't intend to discriminate against families with children, but that's the impact of creating a policy that says no source of or no voucher programs. Okay, so that's why governments are starting to look at this. And then they really, when you think about it, a lot of people with fixed income, so vouchers aside, a lot of people with fixed incomes that rely on programs like Social Security have disabilities and they may not work. So they're not going to pass your 3 times the rent screening test, but they do have income from the federal government and they have vouchers from the federal government to obtain housing. So they are guaranteed that money, but they don't get their money through traditional employment because they are disabled. And having a program that prohibits vouchers would disproportionately harm people with disabilities. And obviously, anything that will contribute to the homelessness population is not going to be very popular with federal government. So, I know what you think. Juana, my landlord does not want to participate in this program. They don't want to be a Section 8 landlord, like the the association doesn't want it, the landlord doesn't want it, they just don't want it. They don't want to jump through those hoops. And oftentimes those hoops are things that you're already doing. It's inspections, right? Many of you have quarterly inspection programs. Section 8 generally requires an initial inspection and an annual inspection, right? So it makes sure your landlord understands the program before they assume this is not what we want. Veteran voucher programs, same thing. Just make sure they understand that it may not be as burdensome as they think in their mind. So your landlord doesn't want to participate in the program. That unfortunately, and this is directly from the Hillsborough County website. Landlords' reluctance to participate in the program is not going to be a legal basis to deny someone who is otherwise qualified but has Section 8 vouchers, okay, or some other type of limited source of income or voucher program. The landlord requires 3 times the rent as a screening tool. Okay, they can still screen. They can they can credit screening, they can do background screening, they can do all those things. But don't assume that someone who is in dire financial straits or on a lower income status or on a fixed income has bad credit. That may not be the case. So you still get to screen them, but you only get to screen for 3 times the amount of their portion of the rent. So if it's $2,000 and their portion is $500, then they only need to show you that they make $1,500. They don't have to show you that they make $6,000. Ooh, I hope my math is right in that because I didn't practice that. And I tell you, I went to law school for a reason because I don't do the math. So I think I did that right, I think. But anyway, the point is 3 times their portion of the rent, not 3 times the total, okay? Landlords are often asked to participate in this program and asked to reduce their rent. They don't have to reduce their rent. They are still entitled to their fair market rent, okay? But they cannot expect the tenant to make 3 times the full amount of the rent, only the tenant's portion. And if the landlord still refuses, listen, don't get involved. You have obligations under your license, under fair housing, under the code of ethics to not participate in discrimination. So if the landlord still refuses, have the landlord communicate their refusal to the tenant. Stay out of it. If you want to manage the property, once the tenant is secured or whoever the landlord selects is secured, that's different, but do not participate in discrimination. Okay, it's not going to be enough to say, well, it was the landlord's choice. No, don't participate in it. So I mentioned 3 aspects to this new Hillsborough County ordinance. There's the source of income discrimination. We talked about that. And then there are these notices, notice to the tenant in all instances, and even notice to applicants. I probably should update that slide. Notice to applicants, as well as notice regarding late fees. So let's talk first about the notice to people who are even interested in renting the property, not just to existing tenants or renewal tenants. All of them are entitled to this required notice. And here's the language from the notice. And this is the opening language of the notice itself. So lessors, in landlords and lessors in unincorporated Hillsborough County are required to give this notice to any person applying to rent to a rental unit. So not just existing tenants, but any applicant. Where no application is required. So can't say, well, we don't have an application, so we decided not to give it to them. Or we don't have a written lease. We only did an oral arrangement, so we decided not to give it to them. Nope, even if it's an oral agreement and even where there is no written application, this notice must be provided to any tenant and any applicant for tenancy prior to them occupying a rental unit. And it provides an overview of their rights. And some of those that I want to key in on is the fact that they are required to sign this. The landlord is required to sign this. And there's a document retention portion here that I want you all to focus on. It says the signature page should be retained by the landlord, okay? They may as well say here landlord or landlord's agent. The landlord's not going to retain this if you're the one handling the transaction. So please make sure you retain a copy of this signed notice by the tenant affirming that they have received a copy of the notice. You keep one for the landlord, you give one to the tenant, okay? How long do you keep these records? Well, the ordinance itself speaks directly to this, and it says that it's unlawful for a person to allow a tenant to occupy the premises without first being provided a copy. Okay, so make sure you give that tenant a copy, and that you need to keep this for 1 year. Okay, that's what the ordinance says. That is the landlord's responsibility. But I want to remind you all that as real estate licensees, the Florida Real Estate Commission requires you keep all documents associated with a real estate transaction for 5 years, at least 5 years. So 5 years or 2 years beyond the end of any litigation over that document. So usually 5 years, but sometimes it can go well past the 5 years if it's subject to a lawsuit. So a year is the landlord's responsibility, 5 years is your responsibility. Just remember that. So in the document itself, it speaks, this notice, it speaks about discrimination and retaliation are illegal, right? Discrimination. We know discrimination. It talks about we talked about these things, denial of housing, advertising, no vouchers, no Section 8, all these things. That's discrimination in housing. Retaliation is where many people within the industry struggle to understand, what does that look like, right? What is that? What do you mean what do you mean retaliation? And I wanted to give you some examples of what retaliation looks like. And part of where you learn about what this retaliation looks like is by reading literature and reports and studies of fair housing organizations. Just like there was Long Island, New York, this expose, this undercover investigation for racial discrimination in New York, Boston did a very similar tester-driven discrimination expose for source of income. Okay, so this is clear in the fair housing world how you can discriminate and retaliate, even though a lot of our members don't follow this. Fair housing organizations are real clear on what retaliation looks like, and it looks a little something like this. You identify the problem by asking things like, were you denied the opportunity to rent after you mentioned you would be using a voucher? Okay. These are things you want to make sure that you look for and guard against doing, because this is what fair housing organizations will teach these tenants to test you on. Were you quoted a higher price or additional higher fees than other prospective tenants who are not using a fixed income or a voucher? Okay. Well, since I'm not collecting as much rent from them, I'm going to charge them twice the security deposit because it'll deter them, right? Like I'm trying to make it hard for them to want to rent here. So I'm going to charge them twice the deposit. They look for that kind of thing. Were you restricted to certain units or buildings when others in your price range were not? So we're going to put all the source of income, fixed income, voucher people at the back of the property, and all of those who just happen to have kids at the back of the property, and put everybody else in the front near the pool. They look for that. Were you subject to different terms or conditions? Were you denied needed repairs or access to services because you were there by virtue of source of a limited income or voucher? And were you told that you do not qualify for certain incentives, right? Other folks got, a free tile upgrade because they signed a 1-year lease, but you didn't get that unit with the free tile upgrade, even though you signed a 1-year lease, because yours was voucher or source of income and you were deemed not as worthy as someone who paid cash. All right. So those are the types of things you want to make sure that you are looking for in how you treat people who come to you with source of income, because that is what housing authorities and housing nonprofits are teaching their folks to look for in terms of retaliation. I got to let you in. I don't necessarily have to treat you the same, right? That's not acceptable under the law. That's why Hillsborough County put that in that notice. So what happens if you don't give the necessary notices? Well, there's a $500 fine if the ordinance is violated. No penalties will be imposed on the property manager who fails to comply prior to July 1st. However, for all applicants, new tenants, and month-to-month tenants, property manager must be sure that the notice was given. So all applicants, new tenants, and tenants that go to a month-to-month status, they must be given the notice. All right, last aspect of this, and then we're going to take questions about this or anything else that you may have questions about. So late fee notices. We always like to give due process to tenants. It's helpful in the eviction process anyway. So this isn't a huge surprise, but this particular ordinance is very particular in the late fee requirements that it imposes on property managers. It states that it is unlawful for any person to assess a late fee against a tenant without first providing written notice to the tenant against whom the late fee is assessed, okay, for each late fee assessed, all right? And it goes on to provide that written notice for purposes of this section shall include a statement informing the tenant, and it goes on to state what that must say. All right. The late fee notice may be delivered the same day that the first late fee is charged. But it must, and so when it talks about prior to the initial late fee assessment, it can be the same day, okay? But it can't be before. So it has to be prior to the initial assessment. Remember, the notice needs to include the amount of the late fee being assessed. The notice should include the section of the lease that it is authorized, that's authorizing this late fee, right? These are good business practices anyway. And the notice should include the justification for the late fee. Now, you want to give this notice by either posting it on the front door of the premises. You can hand deliver it to the tenant, deliver it by certified mail, or email it to the tenant to an email address provided by that tenant pursuant to the terms of the lease. You can also provide notice in any other way that the lease was given. I would encourage you, the Hillsborough County site has really good resources about this issue, okay? And also, we partner a lot with Harry Heights. He has some great resources on there. If you want to take a look at his website, we don't promote one attorney over the other, but he does make a lot of his information public facing. So I would encourage you to take a look at his site. So anything else I can answer to you about this topic? Let me, Nico, and Jacob, before we go into questions, I would like to just say, I know I beat this horse to death, and I'm going to keep beating this horse as long as the lawsuits continue to be filed. Please take a look at our resources regarding screening tenants for criminal history. We've talked about this, y'all. They are continuing to get us with these lawsuits. Please take a look at our Take 5 video regarding screening tenants with criminal history. Please take a look at our it's an article that we have posted for advertising for fair housing words. There's information on there about source of income and no Section 8 as well. Please take a look at that because the lawsuits continue to be filed against our property managers for this issue. Now, I've said a lot, and it would be my absolute pleasure to answer any questions you have about the issues I've discussed or any other pressing matters that you want to discuss while you have me.
Sure, absolutely. Well, we did get plenty of questions from the Q&A, so I'm just going to go down a couple of those, and if you have some answers and some insights, that would be great. So, as a note to everybody watching, if you have some questions, we ask you to put that in the Q&A, and so that way we can ask Juana those questions. So, a couple that we have is there any specific training or education that a landlord needs to do before they can start receiving Section 8 vouchers? Can you talk us a little bit through from the landlord's perspective what they need to do?
Yeah, that's hard because there's not a lot of training out there, right? Even if you go to like NAR's website where, you're used to having all of the videos and FAQs and all of this on the Section 8 program, there's not a lot there. It's an issue. There's a void, quite frankly. I will commit to working on some resources for our members, and it's becoming increasingly important, right? Because we are seeing more and more and more local governments adopting source of income. It used to just be Miami-Dade and Broward, but it's spreading. And so we really need to do a better job. I did the NAR Legal Summit last week. And in the pre-meeting with Katie Johnson, this was one of the things we discussed. So I will continue to request that NAR perhaps consider more resources. But whether they do or don't, because it is spreading in Florida, I am committed to Florida Realtors providing more resources on source of income protection for all of you.
Sounds good. And we appreciate that. And Jacob and I will share those links as well to the Take 5 and those other information websites too. Another question that we had is, so let's say you have an existing landlord and existing tenant, and they decide to renew after the July 1st deadline. Are there specific things that we need to do with our existing landlords and tenants, or does this only apply to new landlords and tenants?
You need to make sure they have, if they renew, make sure they get those disclosures. Make sure you give them a copy and retain your copy. Assuming that they are not, qualifying under some type of source of income, the disclosure information is all you need to be concerned with. But if they do have a limited income, or if you do new screening at the time of the renewal and you discover that they are going to be, they can't meet the 3x the income requirement because they had circumstances that changed during COVID, or maybe now they're on a fixed income, then you need to be mindful of qualifying them under their source.
Okay. Does this apply to both subtenants and sublandlords, or only the original landlord and the original tenant?
I don't recall whether the ordinance language specifically, like expressly talks about that, but because it says all lessors, to me, a subtenant and a sublandlord, if I sublease my property, I'm a sublessor. And I would view that as being captured within the definition of the ordinance.
Gotcha. Another question we got coming in, and this one I'm curious about. Can we, as practitioners, as property managers, can we charge a landlord a different fee for one that has a regular tenant versus one that has maybe a fixed income tenant, a Section 8 tenant? Are we allowed to charge different fees for how we manage a property like that? And I get it. It's a loaded question. Yeah, that's why I wanted to ask you.
Because here's the thing, it's a professional service, it's not providing housing, but it almost seems as though, I'd have to grab my copy of the code. One of the things that it makes me think about is the way that the code is written about not being, a part of a conspiracy to discriminate, right? And it is curious why they phrase it that way. It almost seems like that is contributing to the discrimination, right? And so it does not sit well with me. It's not a course of action that I would condone, because the whole point is the federal government, these local governments are saying there really are no additional administrative burdens on landlord in the instance of Section 8 or voucher housing or source of income situations. So I don't know the justification associated with a listing broker or a property manager charging more for that purpose. Could you legally? I don't know. Should you? I would not recommend it.
Copy that. I think that's a pretty good answer. So how about the scenario in which a property that's currently being rented is coming up for sale? So the landlord decides they no longer want it, they want to sell it. Talk to us about a new landlord, a new investor coming in and purchasing the property. What certain standards are they beholden to, and can they change things once they come in as the new owner?
I think the way that the ordinance and most source of income protection is extended, it's not about the owner. It's about the tenant and their circumstances. And so I don't see that a change in ownership is going to affect the existing tenant's position under source of income protection ordinances. I think that it is possible that at the time of renewing a lease, a landlord, a new owner may have additional screening requirements or something to that effect that may have an impact on that existing tenant and their ability to be able to renew a lease. But that new owner and that new property manager for that owner should be very careful that whatever new criteria they are imposing on that tenant is not for the purpose of pretext to get the Section 8 tenant out, rather than a legitimate screening technique that they will use for all applicants, regardless of their income or voucher status.
Sounds good. So what do we do if we are representing a tenant, or we are a tenant ourselves, and we believe that we have been discriminated against, or our tenants have been discriminated based on this source of income? What are the next steps? What do we do from there?
So Hillsborough County has a complaint mechanism in place, as I understand it. The how to file a complaint is on the notice form. That's one of the important reasons to give and have that copy of the notice, because it tells you what you can do in the event that you feel that you've been discriminated against. As a matter of fact, on this PowerPoint, which I'm happy to send over to you guys, I believe in that discrimination and retaliation slide, there's a phone number for any person who feels that they've been discriminated against to call to report that discrimination.
Sounds good. So how about the idea of, I guess, responsibility? So does this ultimately fall on the landlord's responsibility? Does it fall on us as property managers, or both? But at the end of the day, who is responsible for all of this?
Both. From a fair housing perspective, obviously the landlord is going to have some responsibility to not discriminate, right? And Hillsborough County has made it clear in how they write the ordinance that the responsibility falls on the landlord, right? So they say any landlord or lessee, they say the landlord has an obligation to maintain for a year, all of those things. And so they clearly write it to mean the landlord. But I would say for our members, you are subject to the Code of Ethics, right? You are subject to the Fair Housing Act. You are subject to the Florida Fair Housing Act. And you are also subject to local ordinances that prohibit discrimination. And the reason I walk through some of these aspects of source of income in general is because, again, when you're talking about disproportionate numbers of minorities, disproportionate numbers of children impacted by that type of discrimination, you are now entering into disparate impact, world. And it could go beyond source of income and get into race or familial status or other forms of protected classes that are expressly covered under fair housing. So I would encourage our members, whether the ordinance specifically says landlord or not, through agency principles, as well as through the State Fair Housing Act, through the Federal Fair Housing Act, through the Code of Ethics, and remember the Miami-Dade story about the Section 8 lawsuits, and through liability, through litigation, you can find yourself held responsible for this discrimination. And the litigation, they're not going to sue the landlord. I promise you that. They're going to sue the realtor. And that's not something I think might happen. That's something that has happened routinely in South Florida.
So what about landlords or property managers that own and manage multiple properties in different jurisdictions? Let's say one has a tenant rep or a tenant bill of rights law and another one doesn't. Do they have to have separate, application process, separate rulings for each one, or can they get to say, well, no, because we manage multiple, we can use one template? How does that work within the different jurisdictions?
Risky business, right? It is indeed risky. So your license from the Florida Real Estate Commission allows you to practice throughout the entire state of Florida. But you have to, appraisers have this term. They have to be geographically competent in the area in which they practice, right? Regardless of where they're licensed, they have to have geographic competence. And I encourage members to always ensure they are geographically competent to perform the task that they are performing, which means you have to make sure you are following these types of issues in your various locations, because that might make the difference between I'm going to practice in multiple counties versus I'm going to refer to another county, right? If it's somewhere that you're going to be doing business in all the time, maybe you come up to speed, you learn these local ordinances, you get familiar with that territory, that landscape. If it's, you're in the Central Florida area and you get an occasional property to manage up in Escambia and you're not really sure what the panhandle ordinance is and all that, it might be worth it to just refer that property, because you really have to be mindful of the geographic competence of that area, because if not, you're taking a chance.
All right, I think we got maybe one or two more questions here, then we'll wrap it up. Are there any exclusions or carve-outs from the law that say you're just one landlord, you just own one property, or let's say you own a property and it's $10,000 a month in rent? Are there any specific exclusions like that, or does this apply to every tenant, every landlord, every property, everywhere in the county.
Yeah, see, that's where this gets tricky because the secret that a lot of people don't want to talk about is there are some exceptions on the federal fair housing level, right? For if you own a single property, you don't use a realtor, can you discriminate? Well, yeah. That comes as a shock to some people. There are some exemptions in the federal, let's be real clear, federal Fair Housing Act for individual property owners. Okay. I do not encourage anybody to encourage that or to remember you can't be a party to a conspiracy to discriminate. So don't go around telling your owners, yeah, go ahead and discriminate because you own a single property. That's a conspiracy, an act in furtherance of their discrimination. All right, don't do that. But okay, I did criminal law for a while, so that's why I'm able to rattle off the definition of conspiracy under criminal act in furtherance. But when you read this ordinance and you start to get into code of ethics and some of the other obligations on our members, there's no corresponding, however, if you only own and if you only do, right? So this is why trying to thread the needle with these exceptions and get cute with it can get dangerous because sometimes people confuse, well, when am I able to and when am I not? That's why the best course of action is don't discriminate. Then you're safe, right? Otherwise, if an owner is considering that, tell them to go talk to them.
Sounds good. Well, Juana, again, thank you very much for coming today. As Jacob dropped in the chat, he's got his email in there. If there were any questions that we didn't get a chance to cover today, please email Jacob. He, myself, or Juana will be able to answer those questions. We'll be sure to send out links to today's presentation and video, as well as some other helpful links to every realtor member, every property manager that you might have to be able to learn from this. Just a reminder that this presentation was part of the Government Affairs Committee ongoing monthly series. If you're interested in this topic and other government affairs topics, we encourage you to come to the Greater Tampa Realtors Government Affairs meeting. We meet every Friday, the first Friday of every month at 9:30, virtual and in person, depending on the particular month. So we encourage you to mark your calendars every first Friday of the month at 9:30 a.m. As we wrap up here, Juana, any final comments, questions, or words of wisdom that you would like to leave with our members today?
I just want to thank you all for taking the time to spend with me this afternoon. If we can be a resource to you on this or anything else, please don't hesitate to let us know. And we'll work on that source of income, Section 8, some more training materials. You have my word.
That would be great. We will definitely hold that to you. And again, everybody for tuning in, thank you very much. We hope you have a great rest of your day and great rest of your week. Thanks very much and have a good one. Take care. Bye-bye.